with over 2 decades of experience in international litigation, judicial reform, and anti-corruption.
Thank you. Distinguished members of the Parliament, colleagues and guests, I thank you for the opportunity to speak today about Armenian captives who are currently held in Azerbaijan in full isolation from the outside world. And I also thank European Parliament for the resolutions which reflect the truth and justice. I'm a lawyer. I'm representing those captives before the European Court of Human Rights. Despite internationally recognized absolute right to provide unlimited, unhindered, confidential meetings with the clients, as of this date, none of such meetings were authorized by Azerbaijani authorities. Currently, 20 Armenians are held in Baku. Among them are 8 political and military leaders of Artsakh. They are not simply detainees in ordinary criminal proceedings, but they are effectively being used in relations with Armenia as an instrument of hostage diplomacy. In order to justify the prolonged detention and non-release, Azerbaijan has resorted to politically motivated proceedings and sham trials. These proceedings also serve a broader purpose: to rewrite the history of Artsakh, to criminalize its institutions, and to portray the very existence of Armenian self-governance in Nagorno-Karabakh region as a criminal enterprise. I will address the following 4 main issues. First, the legal status of Artsakh and why public service in its institutions, even in an unrecognized self-declared republic, cannot be criminalized as such. Second, the charges. Third, the fairness of the proceedings. Fourth, the conditions of detention and denial of independent access. Indeed, the Republic of Artsakh was not internationally recognized as a state, but lack of recognition is not the same as criminal activity. The UN Security Council resolutions concerning Nagorno-Karabakh did not declare the independence of Artsakh null and void. They did not call upon all states of the United Nations collectively not to recognize it, as the Security Council did it in other conflicts and contexts, such as Southern Rhodesia, Turkish Republic of Northern Cyprus, or Republika Srpska. Nor did they criminalize engagement with its institutions. For decades, the status of Nagorno-Karabakh remained a matter for negotiation through the OAS Minsk Group, co-chaired by France, Russia, and the United States. Representatives of the Minsk Group engaged with the representatives of Nagorno-Karabakh, including some of the very people now detained in Baku. Representatives of Nagorno-Karabakh also took part in meetings and diplomatic contacts at the international level. At that time, these contacts were not treated as unlawful, nor as participation in a criminal enterprise. They were treated as a part of internationally accepted conflict resolution process. The prosecution appears to treat the political and administrative existence of Artsakh itself as criminal, which is incompatible with the basic principle of individual criminal responsibility. The charges brought against them, political and military leaders of Artsakh, are extremely broad and in many respects represent a striking inversion of the factual and legal reality of the conflict. They include allegations such as planning and waging a war of aggression, despite the fact that it was Azerbaijan that launched the September 2023 military offensive against Nagorno-Karabakh. They include allegations of deportation and forcible displacement, despite the fact that the European Parliament and other international actors have characterized Azerbaijan's actions against the Armenian population of Nagorno-Karabakh as ethnic cleansing. They also include allegations concerning the creation of a criminal organization, unlawful armed formations, unlawful crossing of the state border, terrorism, and other grave offenses. These accusations are not confined to specific acts. They are presented across a vast historic period and appear to attribute decades of conflict to individuals on the basis of their public or political role within Artsakh. This leads to a basic fair trial concern. Where is the individualized conduct? Where is the specific act? Where is the evidence linking that act to the accused person? Where is the causal connection? It is not enough to name a person, place him within a political narrative, and then attribute the entire history of Nagorno-Karabakh conflict to him. Criminal responsibility cannot be based on collective identity, political association, public office, or the mere fact of having represented the Armenian population of Nagorno-Karabakh. This is why these proceedings cannot be understood as ordinary trials. They appear to serve a broader political purpose, to reverse the narrative of responsibility, to portray the representatives of a displaced and victimized Armenian community as the perpetrator, and to criminalize the very political existence of Artsakh after having emptied it of its Armenian population. Let me now turn to the fairness of proceedings. Long before the delivery of judgment, senior Azerbaijani officials, members of parliament, prosecuting authorities, and state-aligned media publicly described Armenian captives as terrorists, criminals, war criminals, members of a separatist junta. These statements presented guilt as already established. In some cases, they addressed the punishment that should be imposed. Armenian civilians were tried before the Baku military court. Trial of civilians by military courts is exceptional and requires very strong safeguards. Those safeguards were absent. The case concerned a conflict in which the Azerbaijani state and its armed forces were themselves parties. The proceedings were formally described as public. In practice, however, international journalists, foreign diplomats, independent civil society observers, family members were not permitted to attend. Azerbaijani state media, however, were allowed to record and report on the proceedings. It allowed the state to control the narrative while excluding independent scrutiny. This brings me to the conditions of detention and the denial of independent access. Following their arrests, Armenian captives were held without contact with their families, without consular assistance, and without access to the international lawyers instructed to represent them. The International Committee of the Red Cross first visited them several weeks after their arrest. Thereafter, humanitarian access became increasingly limited, and the regular ICRC visits ceased in June 2025. Today, the only international humanitarian organization that had access to captives no longer operates in Azerbaijan. The detainees have received no consular visits or assistance from Armenia or from any third state acting on Armenia's behalf. In any effort to remedy the situation, relatives and legal representatives requested to establish protecting power or other third state mechanisms. To date, despite repeated assurances and ongoing discussions about the establishment of peace, Azerbaijan has failed to reach the necessary agreement to enable a neutral third state to visit or assist the Armenian captives. This is one of the most urgent humanitarian concerns before us today. There is also a recent and extremely important development before the European Court of Human Rights, which interprets Armenia and Azerbaijan relations in objective lens. In Viti and others versus Azerbaijan, the court delivered a judgment concerning war crimes committed against Armenian servicemen during the April 26 hostilities. The judgment confirms the beheading of a captured Armenian serviceman who was alive when taken by Azerbaijani soldiers. This judgment, together with other judgments of independent international courts, confirms the very war crimes committed by Azerbaijan against ethnic Armenians. Crucially, however, instead of apologizing for what was done, expressing remorse, or taking steps to execute the judgment, Azerbaijani diplomats have threatened not to implement it, calling it unjust. They do not and cannot genuinely deny the crimes established by the court. Instead, they attack the court for using the terms such as the unrecognized Republic of Artsakh. Here is the dilemma. The same state that committed war crimes and has failed to ensure accountability for atrocities against Armenians is now presenting Armenian captives as terrorists, war criminals, through proceedings, domestic proceedings that themselves amount to a flagrant denial of justice. Azerbaijan must not be allowed to replace accountability with victor's justice. A genuine peace process cannot be built on the imprisonment of representatives of a displaced people, the isolation of captives from their families and lawyers, and the refusal to execute binding judgments of the European Court of Human Rights. The European Union should make the release of the Armenian detainees a central condition of its engagement with Azerbaijan. Pending their release, the EU should insist on immediate and regular access to them by their families, independent lawyers, medical professionals, humanitarian actors, and neutral third country representatives. A third country visitation mechanism must be established without delay. Azerbaijan must consent to it, and Armenia must actively pursue and sustain it through diplomatic channels. The European Union has political influence with both Armenia and Azerbaijan, and it should use them now to make clear that peace without justice is not a peace. I thank you.